it.
Ah, so there we go. So
I
he's looking at
understand.
videos and he's determined that the Kia is the easiest one to break into. So why are you viewing videos on how to break into vehicles?
I didn't view it on how to break it.
I'm no longer approving of their relationship. That relationship is over. He's angry and upset,
I
but
can't text her.
no. People in Texas and other places don't like people stealing things that they've worked hard for. And you,
If you could ask your wife, Mr. Charter, we're hearing her telling you things as you're testifying. If you could just ask her to remain quiet and make.
Suspects, they fled the scene. I had to wait till the cops got there and everything.
Just as the court probably has gleaned from the report, you know, it was very poor decision-making on his part, Your Honor. I mean, he's a young person. He recognizes that he made a very bad choice, and we're hoping the court will follow the terms and conditions of the plea agreement. I do believe he'll be successful if the court gives him the opportunity to work with the court in terms of the specifics that the court may impose on him. But in my interactions, I mean, he's very remorseful, and he definitely understands that he made a very bad mistake. And so he's a young person. He has a lot of opportunities ahead of him. And I'd like to, hopefully with the probation, the deferred, give him a chance of being able to reach those goals.
how old are you?
19.
Why are you stealing cars?
I just made a bad decision. I was tired. I wasn't thinking straight. Everybody's phones were dead and they were stuck in a car. We were riding around at night, hanging out, and then the car broke down. I tried changing the tire of the car, the ABS locked up or something. It wouldn't start up and their phones were dead. And it was a whole bunch of females. It was my girlfriend's friends. So I took a car to take them home and get us home. And
No, you're skipping over a whole lot of things. You're just acting as though, oh, so I took a car to take them home and this is what happened. That's a bunch of nonsense. According to this, you broke into a car. So where did you find a screwdriver to break in the car?
it was in the car.
All right, so the car that you broke into had a screwdriver in it?
No, it was in the car that we were already in.
So you're in a car, you say that car stalls. So your bright idea and the people with you are to break into another car.
It wasn't a bright idea, but that was the idea.
No, I'm being sarcastic. So you, out of all the cars you see in the parking lot, why did you choose the Dodge? Because I'm sure there was more than a Dodge there.
I didn't take a dog.
It was a Kia Soul.
All right, so the Kia Soul. Why did you take the Kia Soul of all of the cars that I'm sure there was more than just the Kia Soul there? So how did you choose the Kia Soul as the one to break into?
I don't know. I just heard of all the videos and stuff of people doing that Kia stuff, and I just knew that it was a.
Ah, so there we go. So
I
he's looking at
understand.
videos and he's determined that the Kia is the easiest one to break into. I'm asking.
Yes, ma'am.
So why are you viewing videos on how to break into vehicles?
I didn't view it on how to break into. I just saw it.
Okay. So how does the conversation go? And you say you're with your girlfriend and these other people. How many people were with you?
It's 4 of us.
All right. So what's your girlfriend's name?
So
So Chloe, what's Chloe's last name?
Olive,
Olive. All right. Who else?
I don't know. Well, Gabby, I don't know the rest of her name, and then Alicia, but I don't know her last name.
All right. So y'all sit around, the car stalls. Do you have a conversation with them? Does somebody say, hey, our car stall and our cell phones died. Bright move. Let's go break into a vehicle. How did the conversation go?
I don't really remember how the conversation went, but we didn't really talk about it like that. We were just like, we're gonna go get a car because we were sitting there for a while. We didn't know what to do. It was late at night, and we didn't really have anybody we could call because our phones were dead. So we just, or I just went.
So there was no convenience store in the area.
Not that I knew. It wasn't my area, so I didn't know.
Oh, so there's no convenience store in all of the area where you were.
Not that I could see.
How far did you go in school?
How did I go up?
Yeah, how far did you go in school?
I graduated.
Where did you graduate from?
Roosevelt High School.
And what have you been doing with the rest of your life other than breaking into this vehicle?
I was a boxer and I was working with my cousin in restoration for a little while.
A boxer?
Yes.
Where?
At Scribner Boxing Gym.
And what's your weight class?
I was fighting at like 140, 147.
And how many fights you have?
I only had one fight until I stopped fighting for school because I had to pick up more hours at work.
All right, and did you win your one fight?
No, ma'am, I didn't. I did way too hard at conditioning. My legs gave out on me in the second round.
So you only went to the second round?
No, I went all the way through, but I lost it to decision because I wasn't throwing any punches. I was too tired.
Who do you live with?
My mom.
Do you have any children?
No.
His mom's here, Judge.
All right, where's his mom? He's making silly decisions. I mean, people get killed for that.
I know.
This is Texas. Nobody wants you breaking into their vehicles. That person, that Kia, guess what? That person worked hard for that vehicle. And for them, guess what that was? That was probably their transportation to work, their transportation to the grocery store. And how would this society be if that person who now doesn't have a vehicle say, I came out, I had to go to work, my cell phone's not working, and my vehicle's gone, so let me break into another vehicle. That sounds so silly. I don't know what they're teaching in school or what's wrong with people.
I understand, Judge.
They stopped teaching civics.
I know. And we've had a long discussion before we appeared before, along with his mom. I mean, we've had some long discussions with him about his decision making. So
And if you're drug tested, what are the results going to be? Tell the truth, shame the devil. What are your results going to be?
Maybe a little bit of marijuana. That's it.
All right, mom, he's doing marijuana. So here's the thing, why are you coming to court asking me to place you on probation and you're still using marijuana?
I'm not still using marijuana.
You want to go, I can send you to the state jail facility.
Around it, so I'm kind of around it, so it's not really out of my system.
Around who?
Me. It's
Now,
just
who are the people you're around?
Well, my girlfriend's family.
All right, well, that's going to end. He's not going to be with her while he's on this probation. I'm no longer approving of their relationship. That relationship is over. He's angry and upset, but you can't be around people that are encouraging, and not a single one of them said to you, let's not break into this vehicle. Did she say, hey, don't break into this vehicle, we'll figure it out?
Said it wasn't a good idea, but I was set on getting home.
Well, then you know what? Maybe her mom would appreciate the fact that you're not around her, because you put her life in danger, and I'm assuming you're supposed to love her. You put her life in danger by breaking into somebody's car. And if she was telling you this is not a good idea, obviously you blew her off. So that's strike number one against that relationship. Strike number two against that relationship is the fact that you're telling me you may be positive for marijuana because you're around it. And then I'm like, around who? And you're like Chloe and her family. That relationship is over while you're on probation. Now, if you still want that relationship, what I can do is you all can rework out your plea bargain agreement, and I can send you to the state jail facility. You can do your time, maybe box at the state jail facility because you need to survive, or at the Bexar County Jail because you need to survive. But then guess what? You'll be off it and you can do whatever you want to do. So which would you prefer? Your relationship, or making a different agreement with your attorney where you go to trial or you go to the state jail facility?
To be fair, Judge, I've been really focused on building a good life for me, my family, my girlfriend. We've been really focused on just doing
Here's
the
the
right
thing.
thing.
I appreciate what you're telling me, but that while you're on probation, that relationship is not happening on this probation.
I know, but no marijuana or anything is gonna be around me. I'm gonna be at home. I'm gonna be around my family. Nothing is gonna be, my mom's gonna be around. 24/7.
Your mom's
I'm
not on
gonna be
probation.
At work, I'm gonna
This,
be.
let me just tell you. In this court, when I have co-defendants and they're involved in certain things, illegal activities, I don't allow them to have contact.
She's
doesn't
not
matter,
involved
no.
in illegal activity.
It doesn't matter if it's the girlfriend, the wife, whoever it is, and you need to concentrate on other things. And you all get together with this group think, and your group think resulted in you remembering some videos on how to break into a Kia. You could have been killed. She could have been killed. People in Texas and other places don't like people stealing things that they've worked hard for. And you know what? If you would have been shot or she would have been shot for breaking in that vehicle, you know what everybody would have done? They would have been watching it on the news and they would have been like, oh, that's a shame. Your mom would have been crying, my baby. They didn't have to kill my baby. And you know what other people would have been saying? Oh, well, he shouldn't have been breaking into a vehicle.
I understand, man.
So that's the Chloe thing is a non-starter at this point in time. You do well, then maybe I'll reconsider the Chloe thing. But for now, that relationship is over. So it's going to be 3 years deferred adjudication. There's to be no contact with Chloe Olive. And I'm going to tell you right now, if you end up having contact with her at some point in time, probation is going to find out about it. If they do, a motion to revoke is going to be filed.
What type of contact? Can I still
No,
virtually contact?
no,
I can't text her?
no. All right, there's no contact with Chloe Olive. And there's supposed to be restitution and no contact with Arnulfo Preneta, Gabriel Cervantes, James Tartar. And I will tell you this, if somebody were Chloe's parents, they probably don't want you around Chloe either. How dare you take my daughter out where she could have been killed because you're still in a vehicle? And if those parents still want you around their daughter after this criminal activity,
I've showed.
I don't know what's up with those parents. There's a $1,500 fine. It will be probated. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be 150 hours of community service restitution. If you obtain a certificate in a trade school or complete some higher level of education, the community service hours will be waived. I'm going to want random field visits 1 time per month for 8 months. Random regular UAs. And we'll start with the UA today and ask them to test for levels, taking consideration 72081. Anything else you need from the court?
Judge, the only thing I would ask is, he does have a grandmother who resides in Oklahoma. She's treating for cancer. I'm not sure what her prognosis is. The family typically goes up once a month to try to,
Oh,
check
just
on it.
like probation. I'm sure that'll be fine.
hopefully he would be able to attend that. But that would be the only concern we would have.
All right, did you review the off the record? Here's the thing. You're young. Guess what? If she's in love with you and you're in love with her at some point in time, after your probation is over, maybe she'll wait for you. Maybe she won't. If she doesn't wait for you, wasn't meant to be, and you shouldn't have put her life in danger. If you loved her, like you say you love her and claim you love her, you would not have put her life and your life in danger by doing that. And so there you go. And her parents probably don't want you around her either. And if they do, I don't understand that. You're taking their daughter into a position where she could potentially be killed because you don't want to take the VIA bus and you say you don't have a ride. But I'm serious. If you end up contacting her, probation is going to find out about it. A motion to revoke will be filed. You will be taken into custody. Your mom will either make bond for you or not. If your mom makes bond for you, then we'll hear that motion to revoke. And you're looking at potentially 2 years in the state jail facility, and that's day for day's time. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
Mom, is there anything else he needs? Excuse me, Mr. Otistor. All right, if there is an issue, you can always call this probation officer, let us know. Once I place somebody on probation, I'm hoping that they'll be successful. All right? You're welcome.
Thanks, Judge.
Mr. Neely? You need to speak up so she can hear. Are you Ezekiel Neely? All right, we're here on a restitution hearing. So the last time we were here, my understanding is that the insurance company paid $7,800.
Yes, Your Honor, another person involved in the case. It was fully reimbursed by his insurance company.
All right, and so the complainant in this case, who is this?
It appears that Gabriel Cervantes, Your Honor, is another person involved in the original offense.
All right, and before we start with his testimony, State, do you have any documentation for the court with regards to his repairs?
No, Your
All right. Does anyone want to call him as a witness?
Honor.
All right, can you raise your right hand for me, please? Mr. Cervantes, raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand, state your name for the record.
Gabriel Guadiana Cervantes.
State, you may proceed.
Cervantes, what type of vehicle did you own or operate?
It was the 2012 Dodge Challenger.
And was it damaged?
Yes.
On what date was it damaged?
On the day of the incident. I'm not too sure of the specific date. It was in November 3rd.
And what happened on that date?
I was coming to a stop off 1604 and 281 when I got rear-ended by a Kia Soul. And the suspects, they fled the scene. I had to wait till the cops got there and everything.
What did you do after that?
I mean, my car was drivable, but I took it straight to the body shop so I could get an estimate and repair it.
Which body shop did you take it to, if you remember?
I'm sorry?
Which body shop did you take it to, if you remember?
It's not known. It's more of a little a little business. But I had sent in the estimate, the estimate for the repairs and everything.
And according to that estimate, how much would the repairs cost?
It was $7,830.
Or did you have those repairs completed?
Yes.
Did you pay out of pocket for those repairs?
Yes, I did.
You were not compensated by insurance, correct?
No, it was not.
Why?
I only had liability and the root insurance from the stolen vehicle. The Kia Soul was telling me that they couldn't do nothing. They couldn't do nothing about it. So I had to pay out of pocket.
Couldn't or wouldn't?
I'm sorry?
Couldn't or wouldn't?
That they couldn't. They couldn't do nothing because the vehicle was stolen.
Understood. Pass the witness.
Any questions?
Yes, Your Honor. Mr. Cervantes, can you hear me okay?
Yes, sir.
Mr. Cervantes, regarding your 2012 Dodge Challenger, when you claimed to have been rear-ended, this was back in 2023, correct?
Yes, sir. Last year, November of last year.
Okay, so by that time, your car was close to 9, 10 years old, correct?
Yeah, I would say so.
It wasn't brand new, it had gone through wear and tear, correct?
Yes.
So it wasn't in mint condition, right?
I wouldn't say mint condition, but it was a sports car and it was in really good condition. I mean,
Now, the incident, you talked about getting rear-ended, is that right?
yes, by the stolen vehicle.
Okay, and you don't know the name of the mechanic shop you took this car to, correct?
Hold on, I could pull it up. ABR Motors.
ABR Motors, okay.
Yes.
Well, you just told us or told the court that it's not known, it's a little mechanic shop, right?
Yes.
Okay, and so you don't know the name of the mechanic that performed any of the work, correct?
Abraham Roveldo.
Okay, do you know exactly what kind of repair he did?
Body, he had to do some body, pull out the the hit from the back, body repair, and then uh rear bumper, trunk, front bumper, front hood, plus paint.
Okay, are you just stating things that you remember, or are you looking at an actual document with a detailed invoice about the repairs he did?
Yes, I'm looking at the actual invoice.
Okay, did you send that to the prosecutor's office?
Yes, I did.
Okay. Regarding the estimate, is that an estimate or is that how much you paid to get those things repaired?
That was how much I paid. The car has been repaired.
Okay, did you give proof to the prosecutor's office that you actually paid that amount you're asking the court to grant you?
Yes, I did.
What did you send the prosecutor's office to confirm that?
I had sent it to Ernest Acevedo. That's who got all the information I sent in.
Okay, but did you send them out, for example, did you send a check that you paid them with to show that you paid that amount?
I had to pay cash.
Okay, do you have a bank receipt where you're withdrawing $7,800 from your bank?
I mean, it was in payments. I didn't pay it all at front, and I wouldn't have the receipts anymore. No, I just got the invoice.
Do you have bank statements that show that over the course of however many months you're claiming to have paid it, you had enough money there to complete the $7,800?
Can you repeat that?
Yes. Do you have bank statements that show that over the course of the months you claim to have paid this, bank statements that show that you did in fact have enough money to cover the $7,800?
Yes, I guess so. Yeah.
You guess or no?
Yes.
Did you give this to the prosecutor?
No, not those.
Okay. Did you give him anything at all?
Just the invoice of the
Okay.
total.
Do you have copy or you have photos of the car with before and after the repairs?
Mm, no, I don't.
And then I'm guessing right now that you're not driving your car, correct?
Oh, I already sold it. This happened last year. I sold it like in the beginning of the year.
How much did you sell it for?
I sold it for 10,000.
10,000?
Mm-hmm.
Okay, that was more than enough to cover whatever repairs you're claiming to have made, correct?
I repaired the car first, paid the 7,830, and then I sold the car for the 10,000.
No further questions, Judge.
Any questions?
No.
Yes.
Sir, do you recognize this document, if you can see it?
Yes,
What is it?
that is the invoice.
Thank you. Nothing further.
Mr. Guadiana, on this estimate that the state just showed you,
Mm-hmm.
it has the amount of $5,300.
That's
Right.
parts. That's parts, and then the labor, and then you
Right.
add it up, and it comes out to the 7,000.
But it doesn't show that it was paid in full. It's just a quote. It doesn't say that this invoice was paid in full, right?
Yes, sir. I got this invoice not too long ago. I mean, the crash was a year ago in November.
No,
I put the car in the body shop, and then I got the car out this year, like in January. of this year. And
No,
then
no, no,
y'all didn't contact me until November of this year, this past November. So that, I mean, that's when I was able to get my hands on the invoice because I thought I wasn't gonna get nothing, you know. I thought it was done, you know, done for
Yeah, no,
until
no,
y'all. Yeah.
we get that. It was an accident. We understand. But
Mm-hmm,
what I'm saying, I'm not trying to trick you, Mr. William. I'm just letting you know that on this receipt that you submitted, you may not see it very clearly. It does
yes, I
not
see it.
state, it does not state that this amount was paid in full. It just has two numbers circled, but it doesn't state that it was paid in full, right?
Yeah.
Okay. And as you told the court a couple of seconds ago, you have not submitted any proof to the prosecutor that you have in fact paid this amount in full, correct?
Yes.
Nothing further, Judge.
All right, any other questions?
No.
Not- that's not very long.
All right. So it appears that we are still where we are before. Number one, I don't have any proof that anything has been paid. I have an estimate that you all have questioned this witness about. It hasn't been introduced into evidence as the estimate. So the court doesn't have an estimate. The court has nothing to make a determination on whether or not he's owed $7,800 for restitution or owed anything for restitution. So do I need to be the person to call his bank, to file a subpoena, to get his bank records to see the installments that he paid to, you know, whatever repair shop that he's saying he paid the money to? And Mr. I'm sorry, Cervantes?
Yes, sir. Yes, Your Honor.
All right. Here's the thing. If the defendant caused an accident, which it appears he did, and if there is an accident to your vehicle, this is what the court needs to make sure that you're entitled to the amount that you're saying. So I'm going to tell you this.
Mm-hmm.
If you paid or withdrew money from your bank account to pay this person, depending on the bank you have, even if it's 3 years ago, they should be able to pull your record, and you walk into the bank and ask them to pull your record, right? And it will show withdrawals. And those total amount of withdrawals should total to what you're saying you paid this person to repair the vehicle. Then the person who repaired the vehicle, if you will go there and maybe they have receipts that they've given you. If you can tell them, hey, please give me these receipts. I need it so I can get a refund or be made whole from the accident. That's what the court needs.
Okay.
Because I mean, and we can go off the record, because here's the thing, anybody can come in and say, you know what, my car, I know my car, but the Kelly Blue Book value is only, or Carfax is only $5,000, but I spent $30,000 to repair it. And you see how it would be wrong for me to just accept the person word that is 30,000. So that's what I need. So
okay.
are you
More
going to go?
proof?
Yes.
Okay.
Are you able to get that to the court?
Mm,
And
I
let me
mean, I
just tell you, I will give you time to do that. Unless you all want to get together and agree on an amount and call Mr. Cervantes and see if he's agreement to the amount that you all want to agree on, because it's clear to the court that he owes him something. I just don't know the amount. So
Right.
if you all want to confer with Mr. Cervantes, the attorneys, and come to an agreement on an amount for restitution, or either he can give me that information. So do you have Mr. Cervantes' number?
Yes,
All right, so if y'all will go and discuss with Mr. Cervantes, maybe y'all can come to an agreement on the amount. And I understand, Mr. Cervantes, when you only have liability, you know, it really doesn't cover everything necessarily. So if you all can do that, they're going to call you right now, Mr. Cervantes. And let me just tell you, I'm not forcing you to agree with whatever they think would be just for you. If you think that's not the payment you should be receiving, just give me that information and I will hear it, okay?
Okay. Yes,
All
Your
right.
Honor.
So do you understand everything that I'm requesting?
Yes.
All right, so you can sign off for now. The prosecutor is going to call you and he's going to speak with the defense attorney and see if you all can come up with the restitution amount.
Okay,
All right, thank you.
thank you.
For bank records or some type of receipt to show that that amount has been paid.
Mhm.
Did you receive a receipt from the repair shop that performed the repairs?
Yes, I did, but I mean, I don't have no proof. So I don't have no proof. I don't even own the car anymore. The car, I already sold it off. So I mean, it's all right. I'm just wasting time, honestly, from work. It's all right.
All right, thank you so much. So Mr. Cervantes, it's just that I need proof
Mhm.
of the amount that's been paid.
Yes, we spoke about it. I couldn't get no proof from my bank or from Mr. Robert from the auto shop. I think somebody called Mr. Abraham, and he said that he will like testify and say that he actually fixed my car, but I don't know how that works. I haven't looked into it at all. I've been busy at work.
All right, thank you so much. I appreciate your coming in.
Okay.
2023, were you involved in an automobile collision?
Yes,
And did you suffer personal injuries as a result of that collision?
I did.
Would you please describe the circumstances of the collision?
Judge, I'm gonna
Uh,
object to asked and answered. The supplemental report that we have shows that Mr. Tartar was reimbursed from his insurance company for the amount of $7,822.78. So he has no more claim for restitution unless he's trying to double dip. But Mr. Tartar's been paid in full.
All right, Mr. Tartar, have you already been paid through insurance for the amount of restitution?
What they paid, the $7,000 was for the damage to my vehicle.
Okay. And so what are you asking for payment for then?
For the outstanding amount from my health coverage, from what the hospital, my insurance did not cover from the hospital. I had a $500 deductible and almost a little over $8,000 that my insurance would not pay.
All right, if you want to address those issues, and I will tell parties if my understanding of the law, if he's out of pocket his deductible, then that needs to be paid.
Yes, Your Honor.
All right, so I'm assuming both parties can agree that the deductible of $500, if that has not been paid by insurance, which won't because it's a deductible, that he is definitely owed $500. Is that correct, defense?
Yes, Your Honor.
All right, so we already have the $500. You will definitely receive restitution for that.
Thank you, Your Honor.
All right, now let's address the other issues. He's saying that there are some medical bills. If y'all want to question him concerning that, please.
Mr. Tartar,
Yes, sir.
what services did you receive after this collision?
It was an examination and x-rays, and then they gave me some pain medication.
And how much were you billed for this examination and x-rays?
Over $8,000. I sent the receipt to Mr. Edelman. Or it wasn't a receipt, it was the explanation of benefits from my insurance.
And the explanation of benefits was that amount?
Do you think he received any money from the sale?
I doubt it, but I don't know.
All right, because that's the only other problem, because I didn't know that the vehicle had been sold. I don't think that came out from the last testimony the court heard. It just came out that he never received the vehicle.
That's right.
All right. And according to this, it appears that they sold it. The sale price was $1,200 at auction. Am I reading this correctly? And that the receipt total was $1,352.
Believe you were correct.
Yes, Your Honor.
And let me see. All right, and at his testimony, he said that the Blue Book value was $8,900.
That comports with my recollection, Judge.
Okay. So we do know, so the Kelly Blueback value, putting it at 8,900 and then deducting the 1,300, which I think that should be deducted. If, and then that would leave a balance of,
Approximately 7,600.
yes.
That's correct, Judge.
So that's what I think the restitution should be for Mr. Pernada. Is there going to be any objections to the court finding that as the restitution amount?
Not from defense counsel, Judge.
I think it takes into account something that is not in evidence, which is whether Mr. Pineda was compensated for the sale of his vehicle.
Well, the reason why I'm deducting the 1,300, because they're saying that they sold it for 1,352, which may suggest that's what it's worth. But I'm taking in consideration that it's an auction, and sometimes with auctions, they have a price that if it doesn't go beyond, I mean, if it goes below that, the set price, they won't sell it. I don't know because I'm not involved in this auction. So I am deducting the 1,352 because he's saying he put his Kelly Blue Book value at 8,900. And I believe he said that was because the vehicle was at, I don't know, I think he said good condition, not excellent condition. I don't know if it was at excellent condition or not, but the defense is agreeing to the payment of the 7,600. Is that what you said, counsel?
Yes, Your Honor.
All right, the $7,600. So if y'all want to go on the record, we can go on the record. But I'm going to put the amount at $7,600.
There is one additional issue for Your Honor. That is
Yes.
for Mr. Tartar.
All right, and he's online.
Yes,
Let's bring him in. All right, which party would like to ask questions?
I believe Mr. Cabañas said this.
Mr. Charter, good afternoon. I'm going to ask you some questions regarding your explanation of benefits document that you submitted to the prosecutor's office.
Yes, sir.
Do you have that in front of you?
I do not.
Okay, well. to the
I
best
haven't,
of your
I haven't,
knowledge- What's that?
I do have an image that I could pull up.
If you can, please, hopefully you're not driving, but if you can, that would help out the court.
All right, are you driving, sir?
No, ma'am. No, ma'am. I am in the passenger seat.
All right, thank you. All right, I don't know if your wife has somewhere that she needs to be that is an emergency, but if you all could pull over, that would help because you're hitting dead spots. So you're going in and out for the Zoom.
Understood. Bear with me just one moment. We will.
Thank you. And so probation, the agreed amount of restitution to Pernada is $7,600. Is that correct, defense?
It is, Your Honor.
State, is that correct?
Yes, Your Honor.
All right. It's Prunneda. First name is Arnulfo, Arnulfo. And the person on the screen now is James Tartar, Tartar.
ER, Your Honor.
Oh, Tarter.
We are stationary.
All right, thank you. Defense, you may proceed.
Thank you, Judge. Mr. Charter, if you have the image of the explanation of benefits, I'd ask you to take a look at it, please.
Yes, sir.
So we
See
see that this is an explanation for services you received on November 4th, 2023, correct?
Yes, sir.
Okay. And this document says that this is not a bill. This is just an explanation of the benefits, correct?
Yes, sir.
Did you submit an itemized bill of services that you received during your visit to the Baptist Hospital on November 4th, 2023?
It was automatically submitted by the hospital. And this came back from my insurance company saying that it was not, they called it ineligible charges.
Okay, no, I understand that, but do you have an itemized bill, an itemized list of the services you received that amounted to this $8,282?
Not at this time. I'm sure I can get one.
Okay. If you take a look at the middle of this page, under the column labeled code, there was a number that's 461. Do you see it?
Yes, sir.
Okay. And then if you go a little bit further down, the 461 explanation by your insurance provider states that it's not that these charges were ineligible to be paid. The explanation is that the claims you filed, these particular claims were in excess of the amount of claims you're allowed in the 12-month period prior to this, correct?
I'm not exactly sure. I believe it's because it went to their insurance first for
Well,
them to try to collect
I'm
payment.
gonna read it to you verbatim, and if you have it, let me know if I'm misreading it. But code 461 states, as stated in the claim filing provision within your summary plan description, claims filed in excess of 12-month filing period are denied. That's what it states, correct?
Yes, sir. I see that, and I'm not
Okay.
sure.
So it doesn't, and if you could ask your wife, Mr. Charter, we're hearing her telling you things as you're testifying. If you could just ask her to remain quiet and make it easier for us to know what you're saying.
Yes,
Okay?
sir.
So what this document is saying is that these charges, it's not that they were ineligible because of the type of incident that occurred. These are just ineligible because you filed claims in excess of the amount you're allowed under your insurance, correct?
I'm not sure. It's saying in excess of the 12-month filing period, but I know it was filed right away.
I
So I
get it.
don't really understand.
Yeah, I know it was filed right away. I understand. I'm just telling you, because again, this document that I'm reading, this is just an explanation. And this is telling you, the recipient, that the reason why these charges were not paid by your insurance, it's not because they weren't covered. It's because you have filed, according to this document, more claims than you're allowed to under your current insurance plan.
Objection, Your Honor, speculation.
That'll be overruled.
And again, and that's just, if you look at code 461 and the explanation, that's just what it's stating verbatim, correct?
Yes, sir. That is what it's stating. I
All right.
feel like I could get some clarification from my insurance company, but I wouldn't have incurred these charges in the first place were it not for the accident. That's my point.
And that's what we're trying to find out. What type of services you received, an itemized description of what they were, to see what you received because of the accident and what you received because of other medical circumstances you may have had on November 4, 2023. And if you could have that to the prosecutor's office, Mr. Charter, I think it'd be very helpful to determine the amount.
Okay, so I need an itemized bill from that visit.
Yes, sir.
Okay, understood.
Thank you, Mr. Charter.
Yes,
All
sir.
right, any questions?
Mr. Tartar, you have
Yes, sir.
sustained injury as a result of a motor vehicle collision caused by Ezekiel Neal, correct?
Yes, sir.
And the total amount billed to you for medical services as a result of that collision was $8,282, correct?
Yes, sir.
And you have not been compensated by your insurance company or any other entity for the financial loss that you incurred as a result of the injuries that you sustained because of Mr. Neal, correct?
Yes, sir. That's correct.
Nothing further.
Anything else?
Nothing further from defense judge.
All right, so Mr. Charter, let me explain to you, and both sides can correct me if I'm wrong. I believe that both sides agree that you were injured. The only question is, what is the amount of restitution? So the document that was given to the state, the amount of restitution is just a blanket restitution. It doesn't say specifically what it's for. So what I can tell you, one, you will not need to come back as a witness. The only documentation the court will need is an itemized list of what it was for. And that's
Okay.
to make sure so that the defense or Mr. Neely will know it's specifically for this and not something else that's just thrown in. Do you understand?
Yes, ma'am.
I don't think that you would throw something else in there that should not be in there, but it's just so that everyone can have it and so that I'll be able to make an order and be assured that my order is a correct one. So you will receive a restitution amount. It's just that the defense is requesting that it be an itemized amount. If for some reason the medical facility that you went to said they're not going to give you an itemized amount, just let the state know and you will receive restitution. It'll just then be for me to make a decision on whether or not it's the full $8,282 or not. Do you understand?
Yes, ma'am.
All right, so whenever you can get that, if you'll turn that over to the state and defense, I'm going to leave this restitution matter open with regards to Mr. Tartar.
Yes, Your Honor.
I'm not going to close it and say that you can't get any restitution because you didn't turn your information in on time. I know how hospitals are and how it is difficult to get information. So just let us know when you can have that available. What I'll do, so we won't lose track of this, I'm going to reset this for 60 days. But if you have it sooner than that, we'll take care of it sooner than that. Do you have any questions?
No, ma'am. Thank you very much.
All right, thank you so much for your patience. All right, so we're gonna come back on April 7th and
I apologize for interrupting. If I receive that information from Mr. Tartar and provide it to defense counsel, can we approach in advance of the April 7th date, since we will not need
Yes.
Mr. Tartar as a witness?
yes. And Mr. Tartar, if you still would like to appear by Zoom, you can still appear by Zoom on that date. So as soon as
Okay.
they receive that information, we'll take care of it, all right?
Yes, ma'am. Thank you.
Thank you. The weather still looks beautiful from your vehicle, so I'm hoping it's still great.
It absolutely is.
All right, you
Thank you.
guys have a great time. Thank you so much.
Thank you. Bye-bye.
All right, so the only restitution amount that remains open is for Mr. Tartar. Is that correct?
Yes, Your Honor.
All right, so we'll recall it for April 7th. And if you all have the information before then, just let the court know.
Yes, Your Honor.
And if we have it before then and your client wants to appear by Zoom, he can appear by Zoom as well.
Thank you, Judge.
All right, thank you. All right, so this is final day for discovery.
On Mr. Neely?
Yes, is it, we're here for discovery?
No, Judge, this restitution, I think this,
Sorry, not discovery, restitution.
And if defense counsel will allow me,
Yes,
the last time that we were here was for Mr. Carter
Yes.
to produce an itemized receipt. He sent me this message yesterday. I have not been able to get an itemized receipt. Insurance cannot provide one at the billing office for the hospital. It's in Houston and has not returned in yet.
all right.
That I understood that there would not be very much that I can do, considering the court's schedule in order, and he responded, I understand.
All right, thank you very much. All right, so then if you want a record, I'll give you a record, but I'm not gonna order any restitution. He'll have to seek other avenues. All right,
Judge,
yes,
and can we just confirm the restitution that was ordered the last time we were in court?
I think it was for our new folk Bernieda.
Yes.
The amount of $8,700, more or less.
I have
let
70.
me tell you what I have.
Thank you, Judge.
All right, there is to be for our new folk, Grenada. It is, I have, yes.
He said, thank you to me, and I said, you're welcome.
Oh, okay. I have $7,600. Is that what everyone has?
That's what I have written
Judge.
down.
All right.
And then for James Tartar, nothing, correct?
Yes.
Okay.
All right. And the reason why And you know what? Let's go on the record. Court is calling 2024 CR 3316 State versus Ezekiel Neely. Could I have parties announced for the record?
Andrew Harris, State.
Good morning, Your Honor. Alfonso Cabañas for Mr. Neely.
And are you Mr. Neely?
Yes, ma'am.
All right, so this restitution hearing was called so that the complainant could provide an itemized list of expenses related to this cause number. State, is there an itemized list?
No, Judge.
And what the court will say is we have had a restitution hearing in this case on October 17th, October 31st, November 21st, December 3rd, December 10th, February 6th. And it was set for February 7th, but the court was in jury trial. And then it was recalled for today for restitution hearing in regards to Mr. Charter. The court has set this for a restitution hearing many times. Defense, what are you requesting?
Judge, with regards to Mr. Tarter, I'm requesting a zero restitution amount since there's been no proof submitted by Mr. Tarter to the state of Texas.
All right, that will be granted. There will be no restitution under this cause number to Mr. Charter. Mr. Charter will help to seek other avenues in regards to restitution. Is there anything else?
And then, Judge, I believe that should be, I hope, the last defendant. And so I'm hoping that this is the last restitution hearing for Mr. Neely.
We all can hope, but I think that was the last person. If there's someone else, then the court will entertain it.
As far as I'm aware.
All right, thank you.
Thank you, Judge.